It's like the same event.
Yes,
Yes, sir.
same transaction.
Okay, well, this is an announcement, and you understand you were charged here with a third-degree felony of evading detention. And, apparently it alleges that the complainant in this case suffered serious bodily injury. So it's a third-degree felony, which carries with it up to 10 years in prison. The other one's not any better, but much worse, escape, which is a first-degree felony, the rate is alleged, which carries with it no less than 5 nor more than 99 years confinement or life imprisonment. And fines up to $10,000 can also be assessed in each of these. Okay, these were both handed up on January 15th of this year. What are we going to do?
Judge, I've been speaking with the state throughout the last vote. We've had some communication issues, but I think we've resolved those. We're trying to get matters resolved. There was a discovery issue that we got resolved last week. So we're talking. It's the best way I can describe it this.
Okay, that doesn't help me. I move forward. And that's once again, it'll be October next week. And this one hasn't been rolling around since the beginning of the year. So how much time do you need for a decision?
It's always part of it was based on the conversation.
I'm gonna give you 3 weeks.
Can we have a month, Judge?
I think we'll be able to discuss it next week.
I heard a whisper over there.
You've got a gap. I believe it's 3 weeks.
Did I know about that?
Yeah.
Or did y'all have some kind of a sinister plan afoot? 4 weeks, good, okay?
Yes, sir.
Yes, sir. Oh,
Thank you.
Francisco Torres is Ryan Gertz. Francisco Torres, are you here? That you? Okay. Have you talked to your attorney today?
No.
Okay.
He's running late. He'll be here.
Just confirm.
That's a false statement. He is not running late. I've never seen Ryan run. I'm not sure he can run, but because I know him from way back. Into it?
I'm gonna say yes.
Yeah, I did. You want one? I got 2 of them. Okay, Carly Fowler, is that you?
Yes, sir.
24 CR 1990. You were charged with the first-degree felony of aggravated robbery, which carries with it up to life in prison. I'm about to dismiss this case.
Really?
Does that make you feel better?
For real? Oh, that's so great.
Well,
Oh, thank
only because it's apparently the right thing to do. The
you.
question is, how did you get I don't want an answer, but how do you get yourself into something like this, And I think, have you learned a lesson out of this whole scenario? Valuable lessons that
Yes,
you
sir.
will use in the future
Yes, sir.
in making judgments. I'm sorry, I didn't ask you. Is this okay with you?
I'm gonna say yes, Your Honor.
Is that your final answer?
That's my final answer. I'm ready to call us teammates.
The case is dismissed. I mean, it's obviously a serious matter, and I don't know how you got into this, but you're getting out of it. But hopefully it made you a wiser person
Yes, sir.
in the way of decision making. Okay, that's done.
Thank you, Your Honor, very much.
2 cases. I don't see dismissals on these.
No, sir, Your Honor. We are, Ms. Sarah was the prosecutor. Last night we were here. The court was giving me an opportunity to go and seal the certified juvenile records. I've been in touch with Mr. Nelson. I really need to file a motion for that. There were loose standards. And so I'm respectfully requesting one more.
He's got 6 cases total.
I have 4 in mind.
Just 4?
Yes, please.
Anyway.
2 incidents complaining witness.
You might not have a new one.
Is there a new one?
All right, I have 2260, 2261, 2262. And in sequence 2263.
25.
Not with,
Oh, yes, it's a UUMV. It's a state jail.
That's official.
00.
it's not.
Might just be out of order. If not, I'll print it out.
Still using a numerical sequence method on.
Yes, there we go.
I forgot about the page. It's not important in my offer. So.
Okay. Hey, Ellie. It doesn't get much more serious than this.
Yes, sir.
And these are 4 aggravated sexual assaults of it looks like 4 charges involving 2 separate children.
Yes, all juvenile children,
Is that right?
Yes, Your Honor.
including the defendant.
And then the other one is unauthorized use of an oil vehicle, which I guess is state jail felony. It is. So what did you say?
Your Honor, last time we were here, the court was allowing me a reset to try and go ahead and get the certification records because our client was a juvenile at the time of this. I did attempt to get those records. That was blocked by the district clerk's office. I talked with Mr. Nelson. Mr. Nelson has advised me that, of course, I don't think there can be an opposition, but he would not be opposed for me to file a motion to unseal the certified certification procedure in this particular case. Along with that, I've had some attempts to reach with Sarah, but my mother-in-law went in the hospital and came out of the hospital and got COVID from the hospital. So it's been a little dicey for me since that time. I'm respectfully requesting another continuance announcement to go ahead and do the unseal and to get with Sarah, although I think in this case may be transferred to another.
All right, looking at the dates of all this, so
Yes, Your Honor.
these were 2 children, 8 and 11 years of age. And then the defendant looks like he was 15.
He ranged from
That one-
13 to 16 in the offense dates. The children ranged from 7 to 8 in the offense dates.
The defendant's birthday is in May of 03.
Correct.
So December 11th of 18 would have been 15 he would have been 15 in 262. December 11th, 2019, he would have been 16.
Yes, I think there are some offenses that are not alleged in the indictment. But,
Well, I'm never going
right,
And then 2263, December 14th, 2019, 16 then. On 2 instances, he was 16 and 2, he was 15.
I believe so, Your Honor.
All right, and there's not an issue about age on the unauthorized. He was an adult during the unauthorized use of a motor vehicle. These were all indicted October of last year, right?
Correct, Your Honor. I believe he had a different defense attorney for quite a while.
All right. And these are all first-degree felonies. Generally carry with it up to life in prison in each case. And then the unauthorized use of a motor vehicle is up to 2 years in the state jail. Today, what do you want to do?
Yeah, I'm respectfully requesting one more announcement.
How much time?
Would the court allow me 60 days in this to get to deal with the sealed records, which I didn't anticipate a block from the district clerk like I got, but at the end of the day.
I'll give you 6 weeks. Let's see where we are then, okay? 6 weeks. Let's try to meet it at 6. Okay, you're Mr. Koenig?
Yes, sir.
And Mr. Lane is here. You were charged here in 24 CR 2327 burglary of a building, which is a state jail felony. However, The indictment also alleges you have two prior state jail convictions, one out of Liberty County in 2017 and another out of Liberty County in 2021, which does that enhance this to a third-degree felony?
Yes, sir.
That's correct,
Mhm.
Judge.
So you're looking at no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. If these felonies are accurately alleged, you are not eligible for probation in front of a jury. So it's all or nothing in front of a jury.
Yes, sir.
What are you going to do today?
Your Honor, I've not had a chance really to talk with the state's attorney. Last time we were here was our first announcement. We do have discovery in this case. I've gone over with Mr. Koenig, but if the court would just allow me one more announcement, I could talk with the state's attorney and see where we're headed.
Actually, this was the 5th announcement.
Really?
Oh, yeah. We have one here that was on February 4th.
Oh, well,
Then the next one is on May 19th. And the next one is August 5th,
oh, well.
and then August 7th. Something must have happened where you asked for some additional time.
Yes, sir.
And then August 13th. And then here we are today in September. So, I mean, we've been, the announcements began in February. So
I apologize.
That's okay.
Last time.
What can you do about it?
I was here. 30 days.
Yeah, 4 weeks.
Thank you.
4 weeks. Okay. Where are we on? Is there something working?
Your Honor, there was an offer made by Daniel who had this case before me. At this point, the offer remains the same. We can discuss what that is.
Hey, guys, no texting. I'm just kidding you. Don't get me.
We're texting each other.
I'm just texting each other. Can I get in that loop?
Right, thank you, Your Honor.
I just like it. Those guys are working on things. You know, they got, everybody's got schedules. And I Kevin Bond dismissal before the court. So I'm signing that, whoever's on that one.
Thank you.
Spending $25.
That's been,
Dismissed.
okay, that one, Carly Fowler, that's both been dismissed. On Darren Porter, that's you, sir?
Yes, sir.
25 CR 335, you're charged with a second-degree felony of burglary of a habitation, but it doesn't end there, as you know. You've got 2 prior convictions that are alleged, which are serious. One is a second-degree felony burglary in 89 out of the court next door. 252nd, then also out of the 252nd after that conviction in 1989 of burglary of a building was final. It was in the old days when it wasn't a state jail felony. It was a second-degree felony in the old days. Then the defendant is alleged to have committed assault of a child and convicted in that court in 2005. So what we have here is habitual felon status. You're looking at no less than 25 years to life imprisonment. Do you understand? Serious, as serious as it gets next to capital cases. All right. It's been around a while. What are we going to do? And again, here, this is one of those where you're not eligible for probation in front of a jury if you went to trial. So it's pretty much all or nothing there in front of a jury. Okay. Yeah, we've been getting resetting since May. So what are we going to do?
We've been made an offer from the state. We will respectfully ask that this be placed on the trial.
It's set for trial. And how long can everybody be ready?
Whenever you say,
Please.
Judge.
We're going to put this quickly. Okay.
Thank you.
Set for trial. And Please get ready. Brandon Richards. On this one as well. We go way back on announcements. Okay, what are you gonna do on this one? It's a Fisher cut bait day.
Yes, sir. Well, we're respectfully placing this on the trial docket.
Okay. You're looking at up to 10 years in prison. Does he have prior, you know? I don't think so.
You read on top that he just filed.
Hmm.
He filed something this morning. I have it on top for you to peruse.
Systems and it's hard to
I understand. Is that all we're doing today, dealing with this?
This is it, Judge.
Okay, stand by. Let me get the other stuff and then we'll,
Yes, sir.
yes, sir. Who's, anybody here for the state otherwise? Saber? Okay. The MTRP status review, right?
I believe so, yes.
I reached out to her.
So she's not here? Sabra? Sabra Adriana Shivers. Sabra Adriana Shivers or Shivers. There is no answer in the courtroom. I asked the bailiff to call into the hall for Sabra Adriana Shivers. Please. I sense something's amiss. When was the last time? Has she failed to report? Really? She knew to be here?
I reached out to her yesterday. No response, Sean. She didn't answer the phone. I contacted, some sources. They did not answer either. She did respond to an email that I received this morning. Stating that she had a new phone number. And that, she was not aware of the court date.
She's aware. Who said she's not aware of the court date?
She said she was.
When did she say that?
I received an email this morning.
Oh, but she's aware. How could she not be aware? She's telling you she wasn't aware, which means she's now aware of it, right? Okay, well, she didn't appear.
I'm no longer.
A warrant is issued for her arrest. That's all we can do. She's on regular probation. That's a conviction and a warrant shall be issued for her arrest.
Release the without.
Now I've got a warrant for him. And looks like we had a hearing back in 2024 about failing to report. I found true and then continued her on probation. Then the new failings to reports and then showing drugs in her system and not reporting the new address.
About 6 weeks ago, she came in and she said that the reason that the drugs were in her system was because she was struggling with domestic violence and then said that she did have a drug patch and could be continued on probation. I have not seen her since then, but she isn't scheduled until the 7th of next month.
Well, she needs to, we don't have supervision of her when she's doesn't show up. She's gonna do her part. And she fails to show, and she did know about this, correct? All right. Well, when she's arrested, then we'll deal with it, I guess is all we can do. Because those are all serious things that we need to keep updated with. Because there's no excuse for methamphetamine in your system.
Do you want me to tell her in the meeting to include these violations?
No, man. I don't think it's necessary. I think she's got enough problems right now. Okay. Let's support.
Man, letter of support and
This is sentencing road, right?
Yes, sir.
Is that what it is? Something, hold on, I just get put in the file. Okay, we're calling 24CO101, the state of Texas versus LaDonna Renee Lewis, which is you, ma'am. And you were here with your attorney, Mr. Nayland, and the state's attorney. I'm looking at this first letter of support from a Doriel Dorsey. Who is that?
She was a coworker.
It was a very nice letter. I mean, truly, it's this person writes very well and got the point across and thinks very highly of. And then here's another one from it looks like, is it Teresia Robinson? I think that the T is marked out. And that's a very nice letter as well, written on your behalf. How do you know this person?
She's my current supervisor.
Your current supervisor. Which my current supervisor would write me a nice letter. My wife. Once. Marcy thinks I'm doing well. She said, needs work,
Yeah.
but yeah, I'm doing well. This her.
It's improvement. Right now.
I'm getting better, she said. Oh. Okay, earlier here, the defendant pleaded, well, it's not showing, entered, has she already entered a plea?
Yes.
Yes.
Okay, this is not showing on the file, entered a plea guilty to misapplication of third-degree felony of fiduciary or financial property. And the agreement is that the defendant would be placed on probation of a type and length at the court's discretion, and restitution in the amount of $8,966.09 would be part of the order of probation.
Yes, she paid back a big chunk. That's just what's left over.
Is that right?
Yes.
What is the balance? Do
Yeah,
we know?
that's the balance, 8,000 the balance. She paid off about 24,000. It was 37,000 total.
Oh, okay.
That's the balance of it right now.
So the balance is still $8,966.
Correct. Yes, we were trying to get that done before we finished the case.
Okay. How do you have a plan? What is your plan on getting that paid back? Because that's what's in, the quicker you pay it back, the quicker you get rewarded.
Yes, right. Yeah, back as I can.
How is that going to be done in your plan though? Do you have like a monthly plan
Yes, sir.
about how much?
At least 300 a month.
Can you do that?
Yes, sir.
Because I'm going to order at least 300. All right.
There is.
Parties
there
had
is
an
a-
opportunity to review the report. Are there any corrections or changes to it or comments? First of all, defense.
No, you're not.
Okay, state.
Judge, there is a memo that was added on from the complaining, one of the officers of the association, huh?
We just,
Yeah, just got it. So it should
is
be, I don't know if it's in there or not.
it's not.
And Judge, I wouldn't
I
object
don't-
to that letter being part of the PSI. I think we were gonna address that, but since I brought it up. Huseby State says that a layperson shouldn't be giving, shouldn't give testimony on the position for punishment. Also, he was a member of the same association she was. I think I'm sure he's mad, but it actually doesn't really matter on our plea bargaining anyways, but I'm just making that objection to the record that it's an improper part of the PSI.
What's the state saying on it?
Judge, this was an interested party, one of the people that belonged to the association that she stole from. So it'd be like a complaining witness that is voicing their opinion about the plea bargain agreement and as well as the way it affected the members of the organization that she took from and the trust that they placed in her before she took this money.
What's the organization here? The sheriff's?
The sheriff's, yes, sir.
So non-governmental entity made up of governmental entities.
Jefferson County Sheriff's Association.
Yes, sir.
Yes. Oh, it says right, Huseby State, 787 Southwest 2nd, 193.
Once again, has everybody read this pre-sentence report and
Yes, sir.
no other changes?
That'd be the only objection, Judge.
Okay.
No, everything else is correct.
I have no objection, Judge.
I'm sure you're reading this in the report, Judge. This is it's not like stealing cash directly from. It was mostly using the credit card for unauthorized purchases that were personal, not for business purpose.
Okay, so the point you're making.
I just want to make sure that you knew was that she's just like robbing the safe in the middle of the night or anything. I'm just make sure that you knew where that was, how the money came. We figured out what the restitution was. So I had to look for non-association versus association. That's where there was a difference in the restitution versus what was initially alleged as well.
So, no, you're trailing off. Go ahead.
It's as long I'm just making sure that you saw that what that was in there is that it was the use of the credit card, not just going in like pulling cash out of the safe or something.
How does that?
It doesn't change anything.
That's apples and oranges. They're
Yeah.
both fruit.
Yeah,
Yeah,
they're supposed to.
it's-
It's like she's wearing like a burglar suit, go in the middle of the night and break into the safe. That's all
But-
I'm getting at.
But
But there's no excuse in the context as you see, she's remorseful.
I understand, but once again, she was put in a position of trust and misused that
Yes, Judge.
to the detriment of the organization and yeah, sometimes this happens here and there's a big difference between people who are funneling out proceeds and then they're buying food.
Well, this was for a lot of this was for personal family stuff. There's
Cruise payments, cheerleading fees.
truly that's children.
Come
yes.
on.
But it's-
Anything else? I mean, that stings, you know it.
it does, and
I mean, we're not talking about, this is having a good time.
right. She's also lost her reputation for career. and
Well,
everything else, and
well,
and is paid for.
what else could be expected
Nothing.
in this?
Nothing.
She betrayed a position of trust and when you're given a position of trust, you have a lot of flexibility and freedom and numerous people rely on the integrity and the honesty of it. And here we're still out. I mean, that was a significant amount. Good thing you paid as much back as you can because a lot of times folks don't. But here it's still thousands of dollars are still missing, and we're talking about losses since August of 21. This is over 4 years later, and the loss of value of it, is still, that adds up.
Yes, Judge. And we've been doing it for some time too. I think she paid this back before she was charged.
Did she pay back with interest though? No.
No,
I know that doesn't happen, but we all agree it ought to be.
I understand.
It ought to be. It's just not the way it is. But nonetheless, is there, even when they get back the last dime of the actual money lost, they've lost the value over 4 years of it, so they're out.
It's not, and I'm not discounting anything. What
I know.
I was getting at is, I
Let
know
me see this case you're talking about.
the difference that we're talking about is whether it's a deferred probation, whether it's conviction or not. And you can also make a finding that it is not in the interest of justice to ever steal this. And I'd be perfectly happy with that. I just don't want her, I want her to just pay for what she did, but not be forever
Yes, sir. I
hurt for it. And that was the
Good.
kind of the
Well,
the
you're
issue.
being a good lawyer. That's you're representing your client vigorously. Good. You many times folks don't hear, and that it's always a good thing because that's important.
And I didn't highlight the part of that, Judge, but it's pretty much just the last point of error just says that lay witnesses should not give should not give an opinion on proper confinement and punishment.
Mhm.
And that's really all it is. A lot of the other points of error don't matter for our case.
I'm going to highlight.
Oh, yeah, absolutely. That's your copy, Judge. I just didn't want to touch your copy if I was giving it to you. I tried to be suggestive. It's just argumentative instead.
You were referring to obviously the last
Just
two of the last three sentences.
Correct, Judge. That's
Okay.
correct.
All right. And the court has, the district attorney's office has requested the court consider this. And this is referred to as a supplemental PSI report memorandum. And it's from Caleb Mitchell. who is president of the Jefferson County Sheriff's Association, I presume. And your objection is noted, and the court is not going to consider the first and second sentence of the last three sentences of that, but I am going to consider everything else.
Yes.
Because everything else does speak to the harm that occurred to the organization, which is the entity that which is the actual victim in this case, the Jefferson County Sheriff's Association. So, but once again, people from time to time make comments about what the punishment should be, but only the jury and the court really has that final determination, depending upon what the defendant elects. So, anybody else want to add something here?
Nothing further, Judge.
Okay, your request on behalf of the defendant is what?
I'm requesting for a deferred adjudication. And you are very welcome to make a finding that it's not in the interest of justice to ever be eligible for non-disclosure. The statutory authority does allow you to do that. And if you do make that finding, then she can't seal this in the future. And I know that's the big issue is they don't want her to be able to hide this in the future. They wait down the road to ever, be put in that position of trust. And we have no problem with you making that finding, Judge. I think that would be highly appropriate in this case to make the Jefferson County Sheriff's Association multiple in their feelings.
Anything else?
And of course, the restitution, Judge, we know she must pay back the last part of it.
And
Judge, because of the position she was placed in and the organization she was placed in a position of trust that allowed her to work without them looking over her shoulder because they did trust her, and then to come back and find out that she's taking money from them. It's not only hurt that, but it put a black eye on the association itself. So we're asking for a straight probation, that she have a conviction, that follow her everywhere so everybody knows, look out, because if she gets in financial trouble, this is a possibility. We want to make sure that we protect further future victims. And we also make sure that the position she's placed in know that they need to keep an extra eye on her if they do place her in a position of trust. So I think it's a fair resolution for the fact that she took it for such a long time and with the money that she took and from who she took it from.
okay. And ma'am, is there anything that you would like to add here, Ms. Lewis, before the court makes its decision? This is your time. Your attorney has spoken for you.
I prefer she wouldn't, just always makes me
Well, it's
scared.
whatever you wish, and you certainly can follow your attorney's advice. Yeah, nothing else?
Yes, sir.
Okay. You did make a statement to the pre-sentence officer, and here it's related in two paragraphs here on page 2. So you stand by that. Okay. Anything else?
That for the judge.
All right. If nothing further, the court is going to find that Ms. Lewis, you have pleaded guilty in this case to misapplication of fiduciary or financial property, a third-degree felony. You have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at your hearing to find you guilty beyond a reasonable doubt. One final thing, how much credit does she have on service? How much do you have any time serving in jail on this? You went in and bonded out, I guess. She says there's none. I trust that she would know better than anybody else.
Yeah.
One day, that was when you came in and then bonded out immediately, and they give you credit. All right, here's the court's ruling. I find you guilty beyond a reasonable doubt of this offense. And you are hereby that's a third degree felony. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. But I am suspending that and placing you on regular probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You had a total law. There was a total loss here to the Sheriff's Association in the amount of $37,102.91, of which a balance toward that replacement or restitution of those funds in the amount of $8,966.09 shall be ordered to be paid as a condition of probation. And you said, I think, that you could pay as much as $300 per month.
Yes.
And that will be ordered. At least $300 per month will be ordered to be paid toward restitution. There will be terms and conditions of probation, which are normal and customary. The court would also add for the record, this particular situation and crime involved illegally taking advantage of a position of trust. You understand that. It's obvious that you have admitted in an attempt to resolve this in an appropriate way. I just wish we could have talked you into not making those choices in the first place, because these are clearly wrong. And something like this is ultimately going to collapse. Somebody's going to find out about it. There's going to be an audit. It's just waiting to fall. It's a shoe waiting to fall. And maybe that bothered you and kept you up at night. But nonetheless, you had, according to the pre-sentence report, 186 separate transactions that you illegally accessed since August of 2021. And these involved expenditures of that had absolutely nothing to do with the purpose of the money that was properly placed into the sheriff's organization, sheriff's association, that should have been used for the purposes that the sheriff's association statements in their incorporation and what that professional entity was entitled to use those for. And those are limited purposes, but it had nothing to do. It had absolutely nothing to do with what you accessed improperly and used those that $36,515.34 for, such as your daughter's cheerleading, childcare, school fees, rent, utilities, and personal subscriptions, and other personal matters, which also included airline tickets. And we can go on and on, but I think the point is made. You understand it. You have admitted responsibility and are pretty much throwing yourself onto the mercy of this court. And your intent to help your kids enjoy life and provide for them and what they wanted contradicted with the obligations that you had in your responsibilities of honest maintenance and control of the Sheriff's Association monies. And so when something happens like this, the price is serious, as it should be. I just wish I could have whispered in your ear, don't do this at the beginning. But you have accepted responsibility, and that is important. Now, these also, such a betrayal of trust also doesn't just walk out of here without the issue of I can assess up to 180 days in the county jail as a condition of your probation. What do the parties say to that?
Judge, in these kind of cases, the court has always given some, that's a discretion as far as the time. I don't know, since she's paid some back, she should be given some credit for that.
I think so. Yeah.
So somewhere around 30 days, maybe up front.
Judge, now if we want her to pay restitution,
Sir?
he's got $8,000 left. Putting her in jail is gonna take her, I mean, she has a job that now she's gonna pick a felon. We don't want her losing her job and not being able to pay restitution back. That really kind of wasn't our agreement on our plea bargain. We talked about a term of probation is the length and the type, not the
Court's
condition. That
discretion.
I understand that, Judge, but that's
But your argument is don't hold me hostage.
not only hostage, Judge. I'm just
I know you don't, but
I'm giving Mike a hard time because he asked for jail.
you're
That's not-
vigorously
that's what we agreed on. So
and
this
it's
is personally between me and him, not the court.
or
That was not, well, it wasn't part of the plea agreement.
Correct.
That's correct. It
and it's
wasn't.
my discretion.
I understand that.
I can do that up to
But if you-
180 days, and she's going to go to jail. You know,
Well, with an
anybody in a position of trust like this, it's going to go to jail. But what I'm going to do is, what are your days of work?
Monday through Friday.
Monday through Friday. I'm going to order you to serve 30 days in the county jail on successive weekends, beginning each Friday. You must report on it before 6:00 p.m. You'll be released Sunday, and that'll be for 15 weekends, successive weekends, as a condition of this probation. Do you understand? Can you work that out? When can you begin that? Today's Friday. I'm going to give you 1 week. Is that enough time? Beginning next Friday, on or before 6:00 p.m. in each successive weekend, until 30 days are served, or unless this court decides otherwise to reduce that time. Dustin, did you hear that?
Yes, Judge, I was making sure.
Okay.
That's clarified.
Okay, you just want to.
So next Friday
Has
after-
discretion, and
Actually,
we'll see how things
Talk
play
to
out.
me. Okay.
And this restitution, let me ask you this. This still is not $8,966. Is there any possible way you're able to pay that restitution earlier than over time? I don't know. I'm just asking you that. I reward people who do that, if you know what I mean.
Yes,
Towards conditions of probation. Okay,
I've talked with her about it. She,
All right,
She
see what
figured
you-
that out.
all right. Did we cover all the bases on this? Anything else?
Okay.
If not, we are in recess on this.
Thank you.
I'll sign, yeah. Let me sign these orders and get the probation office to get copies to everybody.